I'd also like to broadly welcome the thrust of the bill. I think precisely it is about recognising the reality of family life as it exists today and as it actually always has existed, contrary to the propaganda and the ideology. The reality that over a third of births now in Ireland are outside of marriage, that 300,000 children live with lone mothers, 100,000 children live with unmarried cohabiting couples, over 40,000 children live with lone fathers, and there's over 200 same-sex couples with children. And it's about saying that those children should not be discriminated against because they're children in non-marital families, that their right to have a legal relationship with the people that play the role of parents in their lives, that they should have that right and shouldn't be discriminated against in that sense. In particular, obviously I would welcome the provision whereby unmarried couples, be they heterosexual or homosexual, have the right to adopt children together and be parents together of children. I think it is clear already from the debate that the religious right in this country is going to attempt to use this provision and whip up opposition to the referendum on same-sex marriage. It's the only argument that they have, is to say that people will lose their mother if these two things come through, and therefore to try and stop a referendum that I think the vast majority in society would want. And I think those of us who support same-sex marriage, those of us who are opposed to discrimination against LGBT people, have to consider how we respond to that argument. And I think we should be full frontal about it and to say, look, all the evidence, the overwhelming weight of the evidence suggests that two gay parents are just as capable of being good, loving, caring parents as heterosexual couples are, and to absolutely defend the right and the ability of gay couples to rear children. There's no evidence to suggest that there's any problems whatsoever with that. And to be honest, any belief that there is rooted, in my opinion, in a homophobic outlook that looks at this as being problematic and looking for the problems in the situation. The second key point that I would make is that so I welcome in particular the commitment and the centrality of children's interests and children's rights. It has to be matched in terms of policy provisions by the government. I mean, separate from this, we have an explosion in terms of child poverty. I think there was a recent UNICEF report, that the child poverty rose from 10% to almost 30% between the years 2008 and 2012. Similar figures from Barnardos. Obviously, we know that tens of thousands more of parents will be cut off the lone parents allowance, and so you can have a rhetorical commitment and a legal commitment to the rights of children, but it has to be matched by actual action and actual funding by the government. And that gets to the point here. I mean, I welcome the provisions related to assisted human reproduction, but the reality is for huge swathes of society that's simply beyond people. I mean, this is hugely expensive stuff that isn't covered by the public health service at a very, very minimum. I mean, for one go at IVF, you're talking about €5,000. In most cases, you're talking about significantly more than that. They're huge costs, which in reality put the right of people to try for a family beyond many working class people, be they gay or be they straight. And I think you have to say, as part of this process of recognising the rights of people, you have to say that all couples, including gay couples, should have the right to assisted human reproduction provided free through a public health service. The other point relates to, again, making it real, which again, it means the legal resources to go behind it and the financial resources to go behind it. I mean, this is a very complicated piece of legislation, and it's quite a court-focused piece of legislation. It can result in a significant increase in court cases. The reality right now is that there's a year-long waiting list for people to get access to free legal aid for family law cases. There's a massive backlog of family law cases in the district courts. And so if these rights are to be accessible to people, you need the investment in terms of resources in legal aid, including an expansion of legal aid, so people are able to get the kind of expertise that at the moment mostly is not available to people who are through legal aid, and also for those low-income families who don't qualify for legal aid, assistance for them. I would support the two calls, reforms from the Children's Rights Allowance for a central register for statutory declarations for a joint guardianship, because at the moment it's a similar situation to wills whereby these things can be lost. There is no one central place, but also the establishment of a comprehensive court welfare service to support the rollout of this legislation. It has to be backed by the resources necessary to give people access to the rights that can be legally given through this bill. That brings me to the last point, which is some more particular legal points and questions. One relates to the fact that, none of the provisions in the bill will come into force until there's a ministerial order. That's quite unusual, and I would ask the Minister why that's the case. Is it because the government, the state, won't have the resources to implement it, or is it for political reasons? In relation to the recognition of the father and the 12 months requirement, as it's currently drafted, and I don't think it was the government's intention, but as it's currently drafted, it seems to have retrospective impact, which would be hugely complicating and would create really a minefield. I presume that's not the government's intention, and perhaps clarity could be made on that, including through the form of amendments. There are other difficulties that relate to that aren't covered in the bill, in terms of how is it proven, where does the burden of proof lie, in terms of the mother or the father, and it's a case where there is a conflict, and what kind of evidence can be deduced to back up a claim that someone has been cohabiting for a period of 12 months. The last particular point relates to section 51 of the bill, which allows for application for access by a relative of a child. It was previously the case that you needed to have the leave of court for a relative to make that application. At the moment, that's withdrawn as it currently stands in the bill. Why is that the case? It would seem to potentially create complicated situations where perhaps estranged relatives could apply for access without having leave of access from either the court or from the parents. Thanks.